Group Holdings versus Sample.
Anthony Momina here on behalf of plaintiff R&J Holding Group Holdings, LLC.
Azara Staffel on behalf of myself and my family.
Okay, where are we on this?
Your Honor, this is our motion to seek distribution of the funds held in the court's escrow account related to this case. Just to recap, two $5,000 payments total, which was the lease payment amount.
Hold a escrow account. Appeal bond. If you're already getting lost in the legal jungle, don't worry, we're just warming up. This $20,000 is about to become the center of a serious tug-of-war.
Incidentally, were placed into the account pursuant to the standard escrow order that was entered during the pendency of the case in chief. And then subsequent to the issuance of a judgment of possession, there was an appeal, and Your Honor entered another order, a bond on appeal, under which two additional $5,000 payments were made into the court's escrow account. I've confirmed with the clerk that $20,000 is currently being held. There was an appeal, obviously, hence the appeal bond. That appeal was dismissed by the Washtenaw County Circuit Court. There was a subsequent appeal to the Court of Appeals that was processed as an appeal of right when in fact it should have been otherwise, and that court dismissed the...
Boom. The appeal's officially dead twice. That means the courtroom is now the final battlefield for who walks away with the money. But is it really that simple?
Appeals. So there are no pending appeals on this matter, Your Honor. The matter is final and closed, and as an administrative action, I would ask that the court authorize the distribution of those monies to my client. Thank you.
Response.
Well, according to MCR 3.31, this was an injunctive bond that supposed to protect both of us because we counter-complained against...
Why was it it wasn't an injunctive bond?
It should have been because we applied plaintiff and it wasn't granted, but this plaintiff case still is in pending status with federal court, and we paid $10,000 security deposit. We want them back, and we also paid...
Won't now the defendant is flipping the narrative. Not only are they challenging the payment, they're bringing in property taxes, insurance, even attorney fees. But does any of that actually matter legally here?
For over $44,000 of expenses that we paid the property taxes, we paid the homeowner's insurance, we update and upkeep, and they even charge us attorney fees, Your Honor. And I have the sheet to prove it. And therefore, we are entitled to this $20,000.
Why don't we get clear, first of all, what the $20,000 is? The $20,000 was escrow pursuant to the basically summary proceedings action that had been filed. That is not under Section 3 of the court rules. That is actually under Section 4 of the court rules regarding the issuance of an escrow order. I issued that order. You complied, as counsel has indicated, with 2 months of that. Albeit late, there were 2 payments put in. Judgment was rendered. You appealed that judgment. Also pursuant to the court rules, in, again, Chapter 4, you will see that the bond on appeal, I could have set it theoretically at whatever, or whatever bond, but where there has been an escrow order, that escrow order then...
Pay attention, folks. The judge just laid down the timeline like a legal GPS to initial payments. 2 more, after the appeal, total 20 grand. This isn't just about rent, it's about how tight you follow court rules.
Effectively becomes the bond on appeal. And that's what happened. And so then there were 2 additional payments prior to the dismissal of the appeal that then makes the 20,000. So that we're all, whether we're not on we can all be on the same page or not. That's what happened, and that's why the 20,000 is there. I don't know what you're talking about in terms of injunctive relief. I don't know any of that. That has nothing to do with me in this court. The purpose of that, and the 5,000 was the amount of the lease, basically the lease price of the premises.
Exactly.
All right. You were in possession of the premises up until such time as the writ. I don't know if the writ has been executed or not.
And the return has been filed by the sheriff.
Got it.
Classic courtroom confusion security. Deposit versus escrowed rent. 2 totally different legal beasts. The judge is basically saying, wrong courtroom, wrong argument. Ever wonder how many cases derail like this? Let us know below. Double quotes intro.
So you would have had to have paid that amount to be in possession of the premises up until whatever point in time and during appeal. So I'll let you make additional argument, but it seems to me that the 20,000 should be paid over to the plaintiff because of your occupancy of the premises.
Permission to speak, Your Honor?
Go ahead.
What about our security deposit, Your Honor? What about the payment of property taxes and homeowners insurance they forced us to pay in anticipation of the sale, which they breached the contract and they never did, Your Honor?
That would have to be taken up someplace else in terms of the property taxes and whatever. In regard to the security deposit, the security deposit is the disbursement of the security deposit is taken care of pursuant to an entirely different statute.
I beg your pardon?
There's the Security Deposit Act, which governs how that how that gets returned and or not returned, what it can be applied to. That's not before this court.
Which court is this before, Your Honor?
Pardon?
Which court should I go and ask for return of?
I can't give you legal advice. I'm just saying that issue, I'll put it this way, that issue is not before the court. That has not been raised as the return of the security deposit. Usually is something that takes place after the tenancy. Sometimes it's dealt with during the course of a summary proceedings case, certainly, but that has not been raised here and is not before the court.
I'm raising that today, according to ex parte emergency motion and filed, Your Honor.
I don't know that it would be, I don't know that all of the compliance, Gustavo, the act is very specific about certain things that have to happen in order for an issue under the Security Deposit Act to be ripe to even be heard before the court.
The judge just served a hard truth sandwich. You evicted yourself. That's the legal equivalent of a mic drop. Think that was too harsh or just fair justice? Sound off in the comments.
I'm not even sure all of that's happened. You can't just say, I need you to deal with this. That's not how it works.
Okay, I petition again, Your Honor.